Burn, baby, burn, and go to jail, baby, jail. Maybe. President Trump issued an executive order decreeing that burning the American flag is now illegal.
If you burn a flag, you get 1 year in jail, and you will see flag burning stopping immediately.
Shortly after that, a U.S. Army veteran, the guys who are willing to die to protect our right to burn American flags, went down to the White House to do exactly that.
I'm burning this flag as a protest to that illegal fascist president that sits in that house.
And he was promptly arrested. Okay, hang on now. What about those multiple Supreme Court precedents saying that flag burning is protected First Amendment expression? The president cannot change the law simply by signing an executive order, so what in the world is going on here? Let's see if we can shed a little light on that subject. The Stars and Stripes is a symbol of America instantly recognizable as the physical embodiment of U.S. patriotism. If you're ever here in my hometown of Baltimore, you can visit the Star-Spangled Banner Flag House Museum, where Mary Pickersgill sewed the flag that flew over Fort McHenry during the War of 1812 and inspired Francis Scott Key to write the poem that became the national anthem. I hear they have some cool flag stuff in Philadelphia too. I don't know, something about Betsy Ross. The point is, people have a lot of very strong feelings about the American flag, and a lot of them find it deeply offensive to desecrate it. But one of the things that makes America America is our constitutional right to say deeply offensive things. It is right there in the First Amendment. Congress shall make no law abridging the freedom of speech or of the press or the right of people to peaceably assemble and to petition the government for a redress of grievances. And so, flag burning has a long history as a form of protest against the government. In 1966, a man named Sidney Street burned a flag in the state of New York to protest the assassination attempt on civil rights icon James Meredith. Meredith was the first Black student admitted to the University of Mississippi, and he was leading a march against fear from Memphis to Jackson to encourage Black voter registration in the wake of the 1965 Civil Rights Act. On the second day of the march, he was shot by a white gunman. Sidney Street, a decorated World War II veteran living in New York, was one of many people outraged that the police had failed to protect Meredith. So he took his flag out into public and set it on fire. And when the cops showed up, he said, "Yes, that is my flag. I burned it. If they let that happen to Meredith, we don't need an American flag," which is very clearly political speech. Street was tried and convicted for violating New York State's flag burning ban, and the conviction was upheld by the state's intermediate and highest courts. But it was overturned at the Supreme Court in this really fractured opinion that said it was too hard to tease out whether Street had been prosecuted for burning the flag or for his statements about it, and prosecuting him for his words would clearly violate the First Amendment. But just a few years later, the Supreme Court got another crack at the question, and this time they spoke more clearly. In 1984, a man named Gregory Johnson burned the American flag outside the Republican National Committee meeting in Dallas. The RNC was assembled to renominate Ronald Reagan as their presidential candidate, and Johnson, a member of the Revolutionary Communist Youth Brigade, was not a fan. Standing in front of City Hall, he poured kerosene on the flag and set it ablaze as the crowd shouted, "America, the red, white, and blue, we spit on you." Johnson was charged with desecration of a venerated object in violation of Texas Penal Code, convicted at trial, and sentenced to a year in jail and a $2,000 fine. Texas's highest court reversed that conviction, and the state appealed to the Supreme Court. Here's a picture of Johnson with his lawyer, William Kunstler, one of the most famous First Amendment litigators in history. This time, the court didn't fudge. They assessed whether burning the flag amounted to speech or expressive conduct for the purposes of the First Amendment, and they agreed that it did. They said the expressive, overtly political nature of this conduct was both intentional and overwhelmingly apparent. At his trial, Johnson explained his reasons for burning the flag as follows. The American flag was burned as Ronald Reagan was being renominated as president, and a more powerful statement of symbolic speech, whether you agree with it or not, couldn't have been made at that time. In these circumstances, Johnson's burning of the flag was conduct sufficiently imbued with elements of communication to implicate the First Amendment. The decision was 5-4 and not along party lines, which was a thing that used to happen with some regularity. Firebrand conservative Justice Antonin Scalia joined progressive heroes William Brennan and Thurgood Marshall in the majority, along with swing Justice Anthony Kennedy. Here's an audio clip of Justice Scalia at the oral argument being very Justice Scalia.
Your Honor, we believe that if a symbol over a period of time is ignored or abused that it can, in fact, lose its symbolic effect?
I think not at all. I think when somebody does that to the flag becomes even more a symbol of the country. I mean, it seems to me you're running quite a different argument. Not that he's destroying its symbolic character, but that he is showing disrespect for it. That you not just want a symbol, but you want a venerated symbol. And you don't make that argument because then you're getting into a sort of content preference. But I don't see how you can argue that he's making it any less of a symbol than it was.
The minority included Chief Justice Rehnquist and Justice Sandra Day O'Connor, both conservatives, along with liberal Justice John Paul Stevens. They argued that the American flag wasn't just a symbol, but the symbol, and it should have special status because of its importance to so many people. They said the uniquely deep awe and respect for our flag felt by virtually all of us are bundled off under the rubric of designated symbols that the First Amendment prohibits the government from establishing. But the government has not established this feeling. 200 years of history have done that. The government is simply recognizing as a fact the profound regard for the American flag created by that history when it enacts statutes prohibiting the disrespectful public burning of the flag. But we are not, as a country, in the business of banning speech because it makes people really uncomfortable. Or, as the majority put it, if there is a bedrock principle underlying the First Amendment, it is that the government may not prohibit the expression of an idea simply because society finds the idea itself offensive or disagreeable. And that is why it has been legal to burn a flag since 1989. And so Jay Carey, the veteran who served 22 years in the U.S. Army and even received a Bronze Star, went down to the White House to exercise his First Amendment rights, which he is allowed to do. But this hasn't stopped politically charged media from ignoring the facts and taking sides. Within a day of Carey burning the flag, 80 media outlets picked up the story with about 35% of sources coming from the right, 40% from the center, and 25% from the left. And when you examine the headlines, you see a very specific trend emerge. From the left, veteran arrested, veteran burns flag. From the right, man arrested, man burns flag. And from the center, what are the consequences of burning the American flag after Trump's executive order? The headlines you read first have immense power to shape how you understand the news, and that's why I like to see the news from as many angles as I can with the help of today's sponsor, Ground News. And right now, they're offering LegalEagle viewers 40% off their unlimited access Vantage subscription. Scan the QR code or use the link in the description to get the discount for a limited time. Ground News gathers related articles from around the world and across the political spectrum so you can see the bias and compare coverage. Every story comes with a quick visual breakdown of the political bias, factuality, and ownership of the sources reporting, all backed by ratings from 3 independent news monitoring organizations. And they just added a feature that covers podcasts on major stories. I also love their blind spot feature, which shows you stories that are underreported by either side of the political spectrum, like this related story, a group of men in England who were putting up an English flag when they were firebombed. Burning flags is not just an American pastime. But you would never have seen this story if you only got your news from left-leaning sources, because this story was almost entirely ignored by left-leaning media, with only 13% of sources reporting from the left, 13% from the center, and 75% from the right. That's why Ground News is my favorite way to get the news, and as a legal eaglet, you can save 40% off the Ground News Vantage subscription by scanning the code on screen or clicking on the link down below. This subscription gives you unlimited access to every feature, including the Bias Insight tool and the Blind Spot feed. By subscribing, you'll support an independent news platform working to make the media landscape more transparent and balanced. So click the link below or scan the code today, or we will see you in court. So in 1989, the Supreme Court said that flag burning was legal, protected speech. But that didn't stop the government from taking another crack at trying to ban it. Later that year, Congress amended the Flag Desecration Penalties Act to make it applicable nationwide. Previously, it had just applied to the District of Columbia, but Congress expanded it into a national flag-burning ban and teed it up for the Supreme Court. The law literally said, an appeal may be taken directly to the Supreme Court, which shall, if it has not previously ruled on the question, accept jurisdiction over the appeal and advance on the docket and expedite to the greatest extent possible. And they didn't have to wait long. The day the law went into effect, there were nationwide protests that included flag burning. In fact, Gregory Johnson from Texas v. Johnson and several of his friends burned flags on the steps of the U.S. Capitol. Although the prosecutors didn't charge Johnson that go-around, and boy was he pissed about it. Instead, they charged his friends and another group of flag burners from Seattle, and when the case wound up at the Supreme Court, it was captioned U.S. v. Eichmann. This time again, same 5-4 lineup, and again the majority said, no, we are aware that desecration of the flag is deeply offensive to many, but the same might be said, for example, of virulent ethnic and religious epithets, vulgar repudiations of the draft, and scurrilous caricatures. And you see all those case cites in there? Those are some of the most important First Amendment decisions of the 20th century, barring the government from banning speech even when it is deeply offensive. The court said punishing desecration of the flag dilutes the very freedom that makes this emblem so revered and worth revering. And so, while the Flag Protection Act remains on the books at 18 U.S.C. Section 700, it was dead on arrival thanks to the Supreme Court. So why does Trump think he can still ban flag burning? Well, let's look at that spiffy new executive order and find out. Section 1 says, the American flag is a special symbol in our national life, and desecrating it is uniquely offensive and provocative. So far, so normal. But then it goes on to say that burning this representation of America may incite violence and riot, and American flag burning is also used by groups of foreign nationals as a calculated act to intimidate and threaten violence against Americans because of their nationality and place of birth, which is, as they say, citation needed. Okay, let's start with that part about inciting violence and riot, because that is some one weird trick stuff, and the trick involves deliberately misunderstanding the law and failing to read the actual text of Texas v. Johnson. The executive order says, notwithstanding the Supreme Court's rulings on First Amendment protections, the court has never held that American flag desecration conducted in a manner that is likely to incite imminent lawless action, or that is an action amounting to fighting words, is constitutionally protected. See Texas v. Johnson. Likely to incite imminent lawless action is language from a famous Supreme Court case from 1969 called Brandenburg v. Ohio. Now, Clarence Brandenburg was not a nice man. In fact, he was the leader of the Ku Klux Klan who said a lot of truly horrible things about Black people and Jews at a rally in 1964, after which he was prosecuted under an Ohio law that barred advocating for violence. And the Supreme Court tossed that conviction because your right to say truly horrible stuff is protected by the First Amendment, even if what you're saying is a call to violence. In what's come to be known as the Brandenburg Standard for Incitement, the court held that the constitutional guarantees of free speech and free press do not permit a state to forbid or proscribe advocacy of the use of force or of law violation, except where such advocacy is directed to inciting or producing imminent lawless action and is likely to incite or produce such action. Trump says that desecrating the flag is uniquely and inherently offensive and provocative. So essentially, he's trying to define down incitement by claiming that burning the flag is so upsetting that it definitionally constitutes incitement, which is kind of amazing from a guy who insisted that he had a sacred First Amendment right to stand less than a mile from the Capitol on January 6th and tell his supporters that they needed to march on Congress because if you don't fight like hell, you're not going to have a country anymore. Trump's claim that flag burning is inherently incitement is totally undercut by the language from Texas v. Johnson, the very case he points to in that executive order. There, the Supreme Court said to accept Texas's argument that it need only demonstrate the potential for a breach of the peace and that every flag burning necessarily possesses that potential would be to eviscerate our holding in Brandenburg. This we decline to do. So that dog won't hunt. But what about those fighting words? That comes from a Supreme Court case from 1942 called Chaplinsky v. New Hampshire. There, the court upheld a state law that prohibited any offensive, derisive, or annoying word to any other person who is lawfully in any street or other public place, or any noise or exclamation in his presence and hearing with intent to deride, offend, or annoy him, or to prevent him from pursuing his lawful business or occupation. So, public rudeness, basically. The law was used to prosecute a Jehovah's Witness who got a crowd riled up by saying that every other religion was a racket. I'm not saying that Chaplinsky was the last guy in America prosecuted for so-called fighting words, but if there were a line, he'd be pretty close to the end because, as we've seen, the Supreme Court in the 20th century consistently ruled that the First Amendment protects your right to say really super offensive stuff. And by the way, the Supreme Court has consistently held that the government can't censor your speech because what you say may make other people so mad that they react violently. That's called the heckler's veto. And the most famous case was in 1977 when a bunch of Nazis wanted to march in Skokie, Illinois, a community that included tens of thousands of Holocaust survivors.
I hate Illinois Nazis.
By the time the case reached the Supreme Court, it was largely decided on procedural grounds. But the case still stands for the proposition that the government can't ban your speech just because what you say may piss a lot of people off. And the same goes for flag burning. But since Trump is suggesting that flag burning counts as fighting words, let's go back to that Texas v. Johnson decision one more time. Here's what the court had to say about that. Nor does Johnson's expressive conduct, that is, burning the flag, fall within that small class of fighting words that are likely to provoke the average person to retaliation and thereby cause a breach of the peace. No reasonable onlooker would have regarded Johnson's generalized expression of dissatisfaction with the policies of the federal government as a direct personal insult or an invitation to fisticuffs. So that dog won't hunt either. The Trump administration is not going to be able to shoehorn flag burning into one of the narrow exceptions to the First Amendment just by claiming that it really makes people upset. So what's left? Well, the executive order instructs Attorney General Pam Bondi to get creative. Maybe she should prosecute flag burning as a hate crime or illegal discrimination against American citizens, or maybe a civil rights violation. Again, he's trying to turn protected speech into a crime by relabeling it as something else, when courts have consistently rejected government efforts to do just that and acknowledge that burning the flag to criticize the American government is a legitimate form of political expression. And then Trump says, in cases where the Department of Justice determines that an instance of American flag desecration may violate an applicable state or local law, such as open burning restrictions, disorderly conduct laws, or destruction of property laws, the agency shall refer the matter to the appropriate state or local authority for potential action. As law professor Eugene Volokh points out at the website Reason, that's an invitation to selectively enforce the law in a way that violates the First Amendment. Take, for example, a park where people routinely allow their dogs to run around and never pick up the poop. Now, suppose a protester lets his dog poop on the flag and then gets arrested for violating the leash and litter ordinances. If no one else gets arrested for letting their dogs foul the park, then that's selective enforcement based on the content of the dog flag poopers protest. Incidentally, Professor Volokh didn't talk about dog poop, but he did talk about several laws barring protest outside abortion clinics, which got tossed for violating the First Amendment because they were selectively enforced against opponents of abortion, but not against counter-protesters or clinic escorts. And that made those laws viewpoint-based discrimination in violation of the First Amendment. So if Pam Bondi investigates a flag burner and says that she can't prosecute him on any of Trump's creative theories, but she instead refers him to the park police to throw the book at him for starting a fire, well, that too is selective prosecution in violation of the First Amendment. So watch this space when that veteran Jay Carey, who was arrested for burning a flag in front of the White House, actually gets charged. And while we're on the subject of selective enforcement, Trump's executive order announces that President Trump has long condemned the act of burning the American flag, calling it disgraceful. But it would appear that his outrage over mistreatment of the flag is highly case-specific. For instance, the U.S. Flag Code specifies that it should be displayed in a respectful manner as part of a military or patriotic observance. The flag should never be used as wearing apparel, bedding, or drapery. The flag should never have placed upon it, nor in any part of it, nor attached to it, any mark, insignia, letter, word, figure, design, picture, or drawing of any nature. The flag should never be used for advertising purposes in any manner whatsoever. It should not be embroidered on such articles as cushions or handkerchiefs and the like. The flag represents a living country and is itself considered a living thing. Wow, Pam Bondi's really going to have her hands full. In his executive order, Trump commanded the Secretary of State, the Attorney General, and the Secretary of Homeland Security to deny, prohibit, terminate, or revoke visas, residence permits, naturalization proceedings, or other immigration benefits, or seek removal from the United States pursuant to federal law whenever there has been an appropriate determination that foreign nationals have engaged in American flag desecration activity under circumstances that permit the exercise of such remedies pursuant to federal law. So in English, what Trump wants to do is deport immigrants who burn the flag in protest. The problem is he just tried something similar and got smacked down hard by multiple federal judges. Once was in the case of Mahmoud Khalil, the Columbia University grad student and lawful permanent resident who was arrested in front of his pregnant wife after leading pro-Palestinian protests on campus. Secretary of State Marco Rubio issued an order under 8 U.S.C. Section 1227, one of the statutes explicitly referenced in Trump's executive order, which is also codified in Section 237 of the Immigration and Nationality Act. Under that law, an alien whose presence or activities in the United States the Secretary of State has reasonable ground to believe would have a potentially serious adverse foreign policy consequence for the United States is deportable. After Khalil had been arrested, Secretary Rubio produced a memo saying that Khalil's participation in anti-Semitic protests and disruptive activities fostered a hostile environment for Jewish students in the United States and undermined U.S. policy to combat anti-Semitism around the world and in the United States. And so he said Khalil was being deported pursuant to Section 1227. But Judge Michael Fabiars of the District Court of New Jersey said that wouldn't work. First, he said the law violated due process because it's so vague that a person might run afoul of it by accident. Like, how can a person avoid violating a law that says don't do stuff that might make us think your presence in the United States is bad for American foreign policy? That doesn't mean anything. And the judge says that when it comes to First Amendment protected activity like protests, laws must be at their least vague to survive a First Amendment challenge. Now, this opinion is far from clear. Honestly, it seems sort of like the judge tried to appeal-proof his holding by couching it in 100 pages of unreadable prose rendered in this 1960s mechanical typewriter font. But the point stands that a federal judge just put the kibosh on using Section 1227 to extradite non-citizens for First Amendment protected activity. And the same thing happened with Rumeysa Öztürk, the Tufts University student who was detained after she published an opinion piece critical of Israel. The court said exercising her First Amendment right to speak was not an appropriate ground for detention and determination that Öztürk threatened American foreign policy and endangered Jewish students. So when Trump says that he's going to use flag burning, a legal exercise of the First Amendment, as an excuse to deport immigrants, he may run into some trouble in court. In fact, the whole flag burning ban seems like an extremely dubious legal exercise, however you look at it, unless the entire point of this thing is to keep smashing the culture war button and maybe goading Democrats into defending an activity that most Americans find distasteful. And if that's the plan, it just might work. Thanks, Chief Justice Roberts.
Thank you again. Thank you again. Won't forget.
Now, all this highlights why it's so important to get a great lawyer when you're dealing with your own case. Now, after I started this channel, every week I'd get hundreds of comments and emails from viewers who are dealing with legal problems. And they'd ask, can you help me find a lawyer? How do I know if this attorney is any good? And there's a massive gap in our justice system. It's that people don't know how to find the right lawyer for their specific situation. They're scared, they're overwhelmed, and they end up doing nothing or hiring the first attorney who calls them back. And that really bothered me. So I started to wonder, what if there was a different way? What if we could build a law firm that actually lived up to the values that I talk about on this channel: transparency, accessibility, and putting clients first instead of chasing billable hours. A firm where you don't need to pay anything up front and your lawyers only get paid if you do, to maximize your opportunity for justice. So a few years ago, I decided to fix that problem. I decided to start my own personal injury law firm. And honestly, it wasn't an easy choice. But I realized I was in this unique position. I had this platform, this community, and the experience. Not to get rich, trust me, there are easier ways to make money than starting a law practice. But we did it because access to justice shouldn't be a luxury. Because finding the right legal representation shouldn't feel like playing Russian roulette with your future. And when you work with my firm, you're not just getting a lawyer. You're getting a team that understands that behind every case is a real person with real stakes. If we can't represent you, or you're in a state where we don't practice, we'll take the time to try to match you with an attorney in my personal network of lawyers. A national network of some of the best lawyers in the country who actually specialize in what you're going through, located right where you are, not just whoever happens to be available. So if you're dealing with a personal injury, a car crash, a data breach, sexual harassment, a social security or workers' comp issue, give us a call at the number on screen or click on the link below. Now, I can't represent everyone that watches this channel. I wish I could, but what I can do is make sure that when you need legal help, you have somewhere to turn to that you can trust. So whether it's me handling your case or the incredible attorneys we partnered with, you'll get the same principles of honesty and education that we bring to every video. And if you're dealing with a legal issue and you're not sure where to start, check out the link in the description. Let's have a conversation about how we can help you find not just a lawyer, but the right lawyer for your situation. Because at the end of the day, that's what this is all about, making sure that when life gets complicated, you don't have to face it alone. Which is why when you need a lawyer, you don't just need a legal team, you need the Eagle team.